Good afternoon. Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services Committee for today, which is October 25th. We've been joined by council members Cano, Quincy, Fry, Reich, and Warsami, which is everyone on the committee. There are a number of consent agenda items in front of us, and I'd like to move those first. Those include items number 8, 9, 10, 11, 12, and 13. Are there any items anyone would like to pull on the consent agenda? Seeing none, I'll move the consent agenda. All in favor signify by saying aye.
Aye.
Any opposed? Those items are approved. We'll then move on to item number 1 in our public hearing lineup, starting with item number 1, which is a land sale. Mr. Port, welcome.
Good afternoon. Alfred Port, Manager for Residential and Real Estate Development at the City of Minneapolis Community Planning and Economic Development Department. I'm here today to seek a passage of attached resolution approving the sale of 1505 California Street Northeast through the Vacant Housing Recycling Program to Granville Ricks for $40,800. If Granville Ricks fails to close, approve the sale of 1505 California Street Northeast to Cecil Smith and Gwendolyn Smith for $40,800, subject to conditions. As you recall, in 2005, the city staff at CPED launched a pilot program to create the Vacant Housing Recycling Program to enable us to have a transparent medium to market and sell city-owned vacant lots and structures. This experience garnered from the experiences garnered from the pilot program provided us information to develop a program manual that will inform how these city-owned properties would be disposed. After the creation of that manual, we submitted it to neighborhood organizations and development partners to provide them an opportunity to provide us feedback. Upon receipt of the feedback from those stakeholders, we incorporated some of the relevant pieces into that program manual and came to City Council authorizing the approval of the Vacant Housing Recycling Program that defines the program guidelines for disposition of vacant properties, vacant lots and structures. Upon the Council's authorization, the staff developed, worked with the city IT to place the manual and all relevant materials on the city's website. The manual and all supporting documents are updated on the website once changes are made. Now, on November 6th, relevant to the specific property, on November 6th, 2015, the city acquired the tax forfeited property from Hennepin County through the Memorandum of Understanding where we purchased this property for $1. An informational meeting was held in December of 2015, and because this property was purchased from the county, we had tax title, so it necessitated our having to contract with a vendor to clear the title. And in May of 2016, after the title was cleared, we marketed this parcel for development opportunities. We received 4 proposals, 2 single-family proposals, one from Granville Ricks, who proposed to build a 2,688 square foot, 4-bedroom, 3-bathroom, single-family home that he was going to owner-occupied. The second single-family proposal for homesteaded purposes was from Cecil Edmund Smith and Gwendolyn D. Smith, who also proposed the development of a 4-bedroom, 4-bathroom, 2,575 square foot home with a two-car detached garage. The third proposal was from an owner-occupant who was going to be developing a duplex. And the fourth application came from, the fourth proposal came from a developer who was going to developed a single-family home and market it for owner-occupants, or market it for sale with the hopes of attracting someone that would use it for owner-occupancy. We then, as is customary, sent out a notification to the neighborhood group apprising them of these proposals. And they're afforded a 45-day review period. In July, or on July 26th, we received a notification from the neighborhood expressing an equal preference to the two single-family owner-occupied proposals from Granville Ricks and Cecil Smith and Gwendolyn Smith. The neighborhood had a subsequent meeting in September and tendered us another correspondence. In this correspondence, they advised us that their preference was for the sale to Cecil Smith and Gwendolyn Smith, citing their previous investments in the neighborhood. They, at that time, did not express any preference for either proposal's design. So it was their recommendation was solely based on the Smith's involvement in the neighborhood. The requirement of the program talks about a selection process. Vacant Housing Recycling Program identifies the creation of a team of staff members that would evaluate the proposals, selecting the strongest proposal. In this case, there are 5 criteria that's identified in Section 5 of the manual. The purchasers or general contractors' construction experience. In this case, both of the proposals are working with reputable developers. And financial capacity, and I'll speak to the financial capacity in a few minutes. Extensiveness of scope of work, new construction plans. Both plans we felt were comparable, and plan for occupancy. In this case, both of them are owner-occupied purchasers. And then a well-established or well-estimated construction plan, construction cost. I, along with 2 other staff members, a construction manager and a project coordinator that's involved with this project, evaluated these proposals. And I mentioned that I was going to speak to the financial capacity. As it relates to the financial capacity, we are asking, the program manual speaks to 4 categories. One could bring forth financing from a financial institution. They could bring in cash. They could bring in credit or sales proceeds. And I highlight the sales proceeds and want to just speak in details on the language that's in the manual. It says, it is acceptable for the purchaser to finance a project with proceeds from a pending sale of another property or properties. Purchaser must provide a net sheet from a realtor documenting anticipated proceeds and closing date. Whilst reviewing the application, we reviewed a net sheet, seller sheet from a realtor for the Smiths project. And in that document, it listed the estimated closing date of August 31st, 2016. In an attempt to perform our due diligence, we called the realtor and asked if the August 31st date was still realistic. And the response that we got was he did not have the property listed. So upon receipt of that information, we called Mr. Smith, who advised us that that property was not listed, and he didn't know that it was a prerequisite to the program. We then, based on the information, decided that it made sense to move forward with a recommendation for Mr. Ricks, and based on staff's analysis coupled with the neighborhood's feedback, we're coming to this body asking for the recommendation of the sale of the subject property to Granville Ricks. And staff further recommends that should Mr. Ricks fail to close, we should sell the properties to the Smith as an alternate purchaser, provided they're able to meet the requirements of the program from a financial perspective. I believe that Mr. Pettiford had sent out notification to the proposers advising them of this meeting today, so they may be in the audience. Are there any questions for me?
Are there any questions for Alfred on item number 1? Seeing none, thank you for your report. We'll open the public hearing on item number 1, which is a land sale at 1505 California Street Northeast to Granville Ricks or to the alternative purchasers Cecil Smith and Gwendolyn Smith. Is there anyone here to speak to this issue? Anyone? Welcome, Mr. Smith. You have 3 minutes.
Chair Goodman, members of the committee, it's good to see you again. My name is Cecil Smith and I reside at 1600 3rd Street. I'm here to voice my concerns regarding the lot sale process that has failed my family and our dreams for building a home in the neighbourhood where we've lived almost 20 years. I've had extensive conversations with CPED staff on this matter, and I'm grateful for their engagement at the end of the process, but it should have occurred at the beginning of the process. First, I would ask that if the resolution passes, the RCA be amended, since our proposal clearly included a 3-car detached garage, not a 2-car detached garage, as stated in the RCA. Further, the RCA states we have a conditional commitment from Affinity Plus. We have no such commitment. We have cash documented with a standard verification deposit from Affinity Plus dated within 30 days of the application. This is sadly yet another example of a lack of attention to detail that created a broken process for us. The vacant housing program includes 4 provisions where the process has failed, the first being Section 3, page 1. The program manual indicates the offer to purchase must include a documented closing date on pending sales of real estate as acceptable evidence of financial capacity, which was just indicated to you. We never indicated a pending sale confirmed in the RCA before you. In fact, we stated in the cover letter a hope to dispose of our property to new arrivals. Senior staff stated in writing as recently as October 20th that our offer before you today did not meet the minimum requirements. But by staff recommendation, you are poised to approve, as the alternative purchaser, a deficient application. This is a stunning precedent for the city. You're approving an offer inconsistent with the stated policy standards in your program manual. Further, the offer to purchase application form at the time never indicated a pending sale requirement. Neither did the pro forma. Both these documents have been subsequently amended by CPED with that detail. We were not aware of the vacant housing program manual when making our offer for this lot, and there's nothing stated on the application document directing us to the program manual. Second, on page 5, it states, upon receipt of an offer, staff will review for completeness. Incomplete offers will be provided up to 5 business days to clarify or submit missing information in order to complete the offer, end quote. We made our offer on the 24th of May. We were contacted on August 29th, 3 months later, and asked to clarify in a 2-minute call if we had a purchase agreement with a closing date. The document referenced in Section 3. We did not, and responded accordingly. But this was the first indication to us that there was a problem. We were not provided any time to cure the matter, and we believe the circumstances are the most serious departure from the council-approved process. Third, earlier in mid-July, the offer was forwarded to the neighbourhood as indicated. The manual states on page 5, staff will send the new construction plans and specifications from complete offers to the applicable neighbourhood organisation.
Mr. Smith, your 3 minutes is up. Can you try to conclude? We have your written testimony and email that came to us this morning at 11:59 also.
The selection process does not detail any of the requirements. You saw the selection process in detail. It doesn't specify what is superior or inferior. There is no information provided to the public on how this is adjudicated. So it's open to subjectivity. In conclusion, the program manual selection process was mismanaged and violated. even the resolution before you, violating our rights to due process, equal housing opportunity, and the transparency established by Council under the Vacant Housing Program Manual. I might also add that the City is advertising residential real estate without an equal housing opportunity statement or even logo type on its offerings or program manual, which disregards federal fair housing guidelines. The scoring mechanism has significant missing details that leave the City open to accusations of bias and subjectivity that must be clarified and made public. I respectfully request the committee reject the resolution before you, direct staff to make necessary changes to ensure a more robust and compliant implementation of the program manual, publicly establish objective scoring measures given the deficiencies are detailed, and restart the sale process for 1505 California Street.
Thank you for your testimony. Is there anyone else here to speak to item number 1? Please step forward, state your name and address for the record, and if you could keep your comments to 3 minutes, please.
Absolutely. My name is Granville Ricks. I live in 290 Market Street, International Market Square. I've been a resident of Minneapolis here for about 7 years, and I saw 1505 as a place I could build a new house on. My girlfriend's an architect, and per the Vacant Housing Manual, I went online, pulled it up. The eligibility criteria is stated very clearly. I have 2 offers of lending. One from Truestone, a local lender, which details the $400,000 in capacity, and it's an approval letter. The other piece of lending is from Navy Federal Credit Union, which is also an approval. And these approvals are dated back from June and August, so that's absolutely acceptable. I thought this process has been interesting for myself and my girlfriend. We're very excited about the possibility of being able to build something in the Sheridan neighborhood. We're just ecstatic to kind of build something of our own dreams. So I thank you for your time. I thank you for your consideration, and I appreciate Alfred for our conversations and the recommendation from CPED.
Thank you for your testimony. Is there anyone else here to speak to item number 1, which is a land sale? Seeing none, I'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I would like to move approval of the staff recommendation for item number 1.
Further comments or questions on the motion in front of us? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to item number 2. Mr. Wilson.
Madam Chair, we have a liquor license application before us today by AHG Hewing Licensee LLC, doing business as the Hewing Hotel, to be located at 300 Washington Avenue North. They are seeking an on-sale liquor license with Sunday sales, Class B level of entertainment, and a rooftop. This business is located in the historic Jackson Building at 300 Washington, which was constructed in 1897. This is in the North Loop neighborhood in the 3rd Ward. This will be a hotel liquor license allowing liquor service on all floors and all guest rooms, which there are 124 guest rooms. Intend to have hours for beverage alcohol service of 8 a.m. to 2 a.m. daily. This is a 5-story building. The restaurant will be operated in about 3,700 square feet on the 1st floor. It will be a full-service restaurant with 185 seats. They will offer room service, including alcohol to guests in all rooms, and there will be a rooftop bar and deck, which will seat 140 patrons in the bar area and another 50 in a spa area. There will be an event ballroom on the 1st floor across from the restaurant, which will seat 170 persons. And the applicant does wish to extend their level of entertainment to Class B on the rooftop. A public hearing is required for this application. 148 notices were mailed to residents and property owners within 400 feet of this premises. We also notified the North Loop Neighborhood Association and the Warehouse Business District Association. We received one response from that notification process, and that response was opposed to the application solely for the request to have live entertainment, a Class B entertainment level license on the rooftop. Minneapolis Ordinance 36100 does allow discretion to the city council related to levels of entertainment in any outdoor liquor area, including a rooftop. And in fact, the Ordinance 36100 specifies that the city council must specifically grant a license class up for entertainment in all outdoor area services above Class E. Based on our review of this application, I would not recommend that the city give them a Class B license for the rooftop, only in all their interior areas. The Class B allows unlimited musicians, amplified sound, dancing, DJs, etc. I would recommend that a more fitting license for the rooftop would be a Class C2, which allows acoustic music by up to 3 musicians. Our codes also allow all on-sale liquor license holders to apply for a temporary entertainment upgrade for a special event that they might need. Based on that, my recommendation would be to approve the license at a Class B level on indoors and Class C2 on the rooftop deck.
Are there any questions for Mr. Wilson on item number 2? Seeing none, we'll open the public hearing on item number 2, which is an application for a Class C2 license for a new business at the Hewing Hotel. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. Mr. Wilson, just to clarify, so under C2 license, that would be up to 3 musicians allowed. They would also allow ambient music to be amplified. Is that correct? Ambient house music?
Madam Chair, Councilmember Fry, yes. Outdoor liquor establishments can have amplified sound, such as background music, as long as it does not exceed the ambient levels and escape their premises so that it disturbs the repose and well-being of other areas.
And temporary expansion of premises, they can be applied for up to 20 times per year, I believe is the figure.
Madam Chair, Councilmember Fry, that is correct.
Okay. So the conclusion that I will move forward the licensure for C2 on the roof as well as B on the rest, which was Mr. Wilson's recommendation, and that's to allow for quite a lot of great activity to happen inside, some activity to happen on the roof, and if we want to if there's a larger party that's in store, then they can move that forward on a temporary basis. So I think this is a really nice conclusion. So I'll move that item.
Item number 2 has been moved by Councilmember Fry. All in favor signify by saying aye.
Aye.
Any opposed? The chair votes no. That item has been approved. On to item number 3.
Madam Chair, we have another on-sale liquor license application for a new business again. This is by a Minnesota LLC called Downtown East LLC. They'll be doing business as McKinney Row at 530 4th Street South. This is in the newly constructed Wells Fargo 550 Tower. They seek an on-sale liquor license, entertainment level Class C2 for indoor areas, Class E level outdoors. Again, Class C2 allows 3 musicians indoors. This is in the downtown west neighborhood in the 3rd Ward. This restaurant will have seating on the inside for 275 persons and outdoors of 150 people. The applicant, Downtown East LLC, is owned by multiple investors. The president of this company is Dermot Cowley. He owns and operates O'Donovan's Irish Pub in Minneapolis near Target Center and has for many years. And he also owns and operates 2 other suburban restaurants. McKinney Row will be a full-service sit-down restaurant, and they will occasionally have live acoustic bands performing, and they have requested hours of operation from 10 a.m. to 2 a.m. daily. A public hearing is required because of this new business application. 51 notices of this hearing today were mailed to residents and property owners within 400 feet of the premises. We also notified the East Downtown Council and the Minneapolis Downtown Neighborhood Association. We received no responses for or against this application. We find this application meets all of our requirements and would recommend that it be approved.
Are there any questions for Mr. Wilson on item number 3? Seeing none, we'll open the public hearing on item number 3, which is a new business at 534th Street South. Is there anyone here to speak to this issue? Anyone?
Come on, Dermot. Give us something good. A little bit of division.
Madam Chairman, councillors, McKinney Row, we're super excited to get open here with everything going according to plan. November 11th, we'll open to the public. It'll be a contemporary American restaurant right here just across the street, and we look forward to being a great asset to the new neighborhood of downtown East or East Town, and to being a great community ambassador to enjoy the commons, enjoy a great meal, enjoy a great activity, and a great place to hang out on Vikings Day too. So just very excited to get open and get ready. So thank you.
Congratulations. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. I enthusiastically move approval of this item. I think it'll be an extraordinary addition to East Town. The Commons, as well as our atmosphere around here at City Hall. We could use a couple more restaurants in the vicinity, so
Or at
looking
least more
forward to
liquor.
it. At least more liquor, yeah.
Okay. On Councilmember Fry's motion to approve, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on to item number 4. Mr. Wilson.
Thank you, Madam Chair. We have another new business application by Double Black Diamond, Inc., doing business as Red Rabbit, to be located at 201 Washington Avenue North. They are seeking an on-sale liquor license with Sunday sales to be operated in conjunction with a full-service restaurant. This location formerly held the imported car service that was located there for many years. This is in the downtown west neighborhood in the 3rd Ward. You'll have seating capacity interior for 125 persons and exterior capacity of seating capacity for 50 persons. They intend to be open Monday through Sunday, 11 a.m. to 1 a.m., and the exterior will also be open 11 a.m. to 1 a.m. The applicant, Double Black Diamond, Inc., is a registered Minnesota corporation. Principal owners are Luke Shimp and Tracy Bakul. Mr. Shimp is the owner of the Red Cow Restaurant located at 201 First Avenue North and 3624 West 50th Street. So they are already alcohol license holders in our city. Because this is a new business application, a public hearing is required. We did send notice to all property owners and residents within 450 feet and the Downtown Minneapolis Neighborhood Association and the Warehouse District Business Association. We received no responses for or against this application. It appears to meet all of the requirements of our ordinances, and staff's recommendation is that it be approved.
Are there any questions for Mr. Wilson on item number 4? Seeing none, we'll open the public hearing on item number 4, which is a new business license at 201 Washington Avenue North. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. And as I don't think I see Luke here, I also enthusiastically move approval of this item. I think it'll be a wonderful addition in North Loop.
On Councilmember Fry's motion to approve, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. On to item number 5. Mr. Wilson.
Madam Chair, we have an application by Trader Joe's East Incorporated for an off-sale liquor license to be operated in conjunction with their soon-to-be-built Trader Joe's grocery store at 721 Washington Avenue South. This is in the downtown East neighborhood in the 3rd Ward. Trader Joe's intends to occupy the ground floor of this mixed-use retail apartment complex and scheduled for completion in 2017. Off-sale liquor stores operating in conjunction with the grocery store will require separate entrances, but other than that, they can be operated together. Public hearing is required. We notified all property owners within 300 feet of the main door of this establishment, also the Minneapolis Downtown Neighborhood Association and the East Downtown Council. We received no responses to that mailing requirement. Staff's recommendation is this application be approved.
Are there any questions for Mr. Wilson on item number 5? Seeing none, we'll open the public hearing on item number 5, which is a new business license at 721 Washington Avenue South. Is there anyone here to speak to this issue? Please step forward, state your name and address for the record.
Madam Chair, my name is Tony Gleek. I'm a lawyer at Siegel Brill who has represented Trader Joe's not only on this application, liquor license, but there are other applications in the metro area. And as we did so in this location, they're very excited to come to Minneapolis. It's been a long road to find a location that everybody's happy with. We're very excited and we're ready to go and get started. And I've got two folks here from other stores, Maple Grove and St. Louis Park, if they have any operational questions. But they know the show and they know how to operate, and I think everybody knows their reputation. So we're here to answer any questions. Appreciate it.
Thank you for your testimony. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. In this instance, I think Uptown's loss is downtown's gain. As you know, downtown is not just a commercial business district anymore. It's very much a neighborhood, and that neighborhood is in need of fresh produce as well as affordable produce. So we're really thrilled to have Trader Joe's on the way. I think it'll be a wonderful asset for the neighborhood, and I couldn't be more pleased to move this forward. Thank you for your work, and I'll thank myself for keeping that quiet for about a year because that was one of the most difficult processes I've gone through. But thank you very much.
Further comments or questions? Seeing none on Councilmember Fry's motion, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll now move on to item number 6, which has 16 subparts. Each of those subparts could have a separate public hearing, but we're not going to do that. We're going to ask Mr. Moreno to give a report and have one public hearing on all 16 items, should he concur with that strategy.
That sounds good.
Thank you.
Good afternoon, Madam Chair and committee members. I'm Nick Magrino, Associate Legal Coordinator in Regulatory Services. I'm here today to seek council approval of our annual special assessment levy covering a number of different fees and fines in 3 different departments. The levy includes things like covering costs for nuisance abatement, vacant building registration fees, emergency board ups, and unpaid administrative citations and reinspection fees. These are 2016 levy year assessments that will be payable with property owners' 2017 property taxes. For all the assessments included in the levy, we gave notice of our intent to assess to either a rental contact, homesteader, or taxpayer sometime over the course of this year, and that notice did include instructions for appeals and prepayments. We continue to accept prepayments up until November 23rd as allowable by law, and then it'll be transmitted to Hennepin County on November 30th. Property owners still have the right to appeal their assessments in Hennepin County District Court after the City Council approves the levy, and I'd be happy to stand for any questions that you may have.
Are there any questions for Mr. Magrino on items 6, 1 through 16? Seeing none, thank you for your report and all the work that went into this. We will open the public hearing on item number 6, including parts 1 through 16. Is there anyone here to speak to these issues? Anyone? Please step forward, state your name and address for the record.
Good afternoon, Madam Chair. My name is Bobby C. I'm an attorney, and I'm representing the Vine Word of Truth Church. And the property address is 3055 Central Avenue Northeast in Minneapolis. And this is regarding the assessment that was made. Apparently, there was several assessments made on the same issue, which is stripping of the parking spaces for the church. I'm not familiar with the procedure here, Madam Chair. However, I do have a written proposal. I have a copy for the council members if you wish to have one before I proceed.
We're not going to take up the issue of whether or not you have complied with the order. You didn't comply with the order, which is why you were assessed. So you'll need to talk to staff about whether or not they have any opinion about how to move forward.
Okay. I actually spoke to the, I believe his name is Mr. Robertson, who was the inspector regarding this matter. And he informed me that there'll be a meeting today and that I can come to the meeting if I have any opposition to the assessment and address, the council members regarding that issue. So I'm not quite clear on
the item in front of us today is adopting the assessment roles of decisions that have already been made and authorizing Hennepin County to move forward in collecting that money.
Correct.
So we're not here to adjudicate every individual case where a property owner says, no, you didn't board my property, or yes, I did the striping. That decision had already been made. But Mr. Magrino perhaps could clarify the process.
Madam Chair and committee members, in your case, I actually do have something on my desk right now. So you did appeal an additional citation that was issued.
That is correct.
But so this hearing is for past citations that weren't paid or appealed and were assessed. So we'll follow up with you about that most recent citation.
Okay.
But this is sort of a separate issue.
I see. Okay. Thank you, Madam Chair. Appreciate it.
Thank you. And Nick, if you could just follow up after the meeting, just to make sure you follow up with him. Okay, great. Is there anyone else here to speak to this issue? Anyone?
Good afternoon.
Good afternoon.
I was hoping there'll be more people to go forward before me so I can see get a little training onto what to expect and what to do here. So I'm a little bit out of my league, but I'm going to give my best shot. I'm here because I had a fire last year that damaged my property at 14. Oh, by the way, my name is Joseph. I'm owner of property at 1411 Emerson Avenue North, and I'm calling here because of a vacant boarded building charge for the fourth year here. And so from what I understood, from where I have a dispute with the city, is that on the website, and even still as of today, the ordinance says we have the information that says the city ordinance allows any building to be boarded for 60 days without penalty. After 60 days, if the owner has not removed the boards or a building permit been issued to rehab the building may be placed on the vacant building registration list. And I interpret that to mean that as long as you didn't abandon the building and you were making efforts to fix it up, to get it going, that you're not going to be charged, you're not going to be put on the vacant boarded building list and then ultimately getting charged almost $7,000 for it. I had a fire on September 15th, I believe, and it was boarded up. I had managed to be there with the firefighter, but I tried to get the boarding to be done privately. I couldn't, so that charge is here today, and I'm not going to dispute that because it was done. It was boarded up. I worked with the city. I talked with Bruce Frame, and he explained the procedures, everything I had to do to avoid it getting condemned and making sure that everything goes on and doesn't get no other more trouble. I went through it. On the 15th, I have it here. On the 15th of October, I got a demolition permit and officially began work on demolishing what I could do on my own, while still working with the bank to try and get not the bank, but the insurance companies to try and get it settled. On the 25th of November, I got a building permit to work on, to start the process. And in March, I was then listed on the vacant boarded building list and charged, and I disputed that. I went to I know they they offer an option that if you enroll in the program, that they will give you up to 6 months in order to finish the project. Well, I had a problem with that too, because we start out with where I got a permit that gave me up to 12 months to complete the project. And then 3 months into it, the city comes back and says, we're going to charge you $7,000. And if you want to avoid that charge, you can get into a contract with us, which says which ultimately says you cannot dispute, you don't have a right to appeal any longer, but you have 6 months to finish the project. And I thought, that's not right. I mean, if I have 12 months to finish it, I'm only 3 months into it. Why would that be? Why is that now being charged for this? So I appealed it. I appealed that to through the first appeal, and it was affirmed. And they told me to come back here and then here, and then the next option would be the November 4 meeting. But I don't know what. I don't feel that this fee, that I should have been charged this fee at all. It's the project right now is ongoing, and I was hoping, my original plan was hoping that by today it would be done. I can be saying, okay, we already moved into it, but that didn't happen. We're behind, and I'm still expecting that probably by the end of by the 1 year anniversary of the permit that I would be done already. But I never stopped working on the project. The project, yes, it was boarded up, but I had no control over it. With the windows all broken out and the demolition going on, there was nothing I can do other than to demolish everything that needed to be demolished and put the windows in and everything. I did all of that, and like I said, the building by the end of November should be complete or close to completion.
Thank you for your testimony. We're not adjudicating at every individual case because we don't get to make a decision individually about whether or not you should have been or should not have been issued this fee. That happens at the staff level. This is just the process of authorizing staff to collect via Hennepin County. So we would ask that you talk to Mr. Magrino in the back, and he can let you know if there is any process left for you to work through staff. We don't view or rule on, like a court, every individual case where someone has not paid a fine or fee, or that they have challenged a fine or fee. That has its own administrative process. It sounds like you went through that administrative process and they said you get assigned the fee and you didn't like that answer, so you're here, but we're not adjudicating individual cases. So I would urge you to talk to Mr. Magrino, who's in the back of the room, unless he thinks that's not correct. Mr. Magrino, do you want to step up here and tell me whether or not that is also correct? Come up here. Is our job to be adjudicating each individual case where someone has been through an administrative process and does not want to be paying the fine?
Madam Chair and committee members, no.
Mr. Fussy, do you want to clarify why we're getting all these individual cases? Who's telling people to come to us when we're in the process of giving staff approval to get the county to charge back for these fees and tell them to come to us and plead their case?
Madam Chair, you're correct. Certainly, I haven't been telling anyone to come to you to plead their case. There is a right to have a public hearing on these matters when you adopt the entirety of the role. Obviously, there are thousands of individual assessments here, and it would be absurd for you to be able to individually adjudicate each one. Each of the assessments have had one or multiple opportunities to appeal at the city level, informal staff discussions, and there will be further appellate avenues once the assessment role is adopted as well. Thank you.
Okay, so I would urge you to talk to staff, and or if you disagree with the decision of staff, the next step would be taking it to district court, as I heard our staff suggest.
So why would they send us notices that say we have the right to appeal